Okay, I think we'll get started. Welcome. My name is Doris Meissner. I'm a senior fellow here at the Migration Policy Institute, and I'm very pleased to welcome you this afternoon to a discussion of an issue that has always been part of the immigration spectrum, but that doesn't get a lot of discussion, and that is labor standards and issues surrounding labor standards, and I hope a new angle and dimension of them that is apparent in work that we've been doing for quite some while here at MPI. I would like to introduce the guests that we have. We have guests on site and we have guests, virtual guests by video. On site we have our report co-authors who are Muzaffar Shishti on my left, who directs our MPI office at NYU, and Andrew Elmore, the co-author, who is on the faculty at the School of Law, NYU School of Law, and former section chief of the Labor Bureau in the Office of the Attorney General in the state of New York. We also then have by a remote or on video, Julie Su, who is the Labor Commissioner of the state of California, and in addition, Abby Hudgens, who is the administrator of the Tennessee Bureau of Workers' Compensation, and she's joined by a colleague, Amanda Terry, who is the director of their compliance programs. It'll become apparent as we talk about all of this why those states and the importance of those states in learning more about these issues. You can, during the course of this event, because we have a live stream audience, tweet questions to @migrationpolicy, or you can use the hashtag, #MPIDiscuss, or you can email events@migrationpolicy.org. And when we get to the question and answer period, those messages and questions that are coming in, we will try to get to in turn, along with those that might be coming from our audience in the room. So with that, let me start this off by saying a little bit more about labor standards and labor standards enforcement in this way. In the immigration world, in debates on immigration over the course of many years and decades, part of the debate surrounding enforcement of immigration laws has always had to do with how do you best enforce immigration laws. And that leads you to the issue of employers and the issue of work in the United States and the issue of people coming to the United States when they come illegally for the purposes of working, but also people that are in the United States as immigrants who are here legally, often being in industries and sectors and occupations that are heavily, have large numbers of immigrants and can be parts of the labor market that are less regulated and where workers are more vulnerable. So the discussion then from an immigration policy standpoint has traditionally been what is the best way to deal with that work magnet and with the role of employers and the responsibility of employers in that work picture. There have been, I think it's fair to say, two quite distinct points of view on that employer picture. One has been, and it's the more dominant discussion, it has been that there need to be employer penalties, employer compliance, and a system for verifying who it is that employers hire. And that can get involved then with documents and with the degree to which employers can be incentivized into complying with the law, etc. The other point of view has been that the proper approach to employer enforcement should deal with labor standards, and that labor standards are the way to ensure an even playing field for all workers, and labor standards is the way in which to more effectively, ultimately, regulate labor markets and the proper and improper employment and working conditions. That debate remains alive and well, even though at the present time we're not having an immigration reform debate of any real likelihood, but these have been the standard issues. What we're going to do today, and what our co-authors have done today, is look at that labor standards issue, but from the standpoint of states and the role of states and the activity of states around the country as compared to the federal level. This is always talked about at the federal level. The federal government has traditionally been quite weak in its labor standards enforcement, even when it's been at its stronger periods. There's now, in this work, another layer of labor standards enforcement that displays and shows some very interesting trends and tools, and that's what this work is about. So that's why we are talking with, later in the session, with commissioners and labor standards enforcement officials from 2 of the states that were in the study, because they're the ones that actually have their hands operationally on what it is that we're going to describe from a research standpoint. With that, let me turn first to Muzaffar, and then we'll go to Ellen.
Thank you, Doris, and thank you for taking part in the live stream, and particularly thanks to Julie, Abby, and Amanda for taking the time to join us. I know they all wanted to be here, but finally the travel schedules didn't allow it. So let me just very quickly say what motivated us to do this work and sort of place the context for then the heart of the report, which my colleague and friend Andrew will talk about. Foreign-born workers constitute about 17 to 18% of the total U.S. labor force. But they're not uniformly spread in the labor force. They are overrepresented in some occupations and sectors of economy, and in these sectors, there is a sizable section of the unauthorized in the labor force. If you could just quickly put that slice up. This was sort of the basic slide about the total labor force, and then what we think are the 3 major sectors where there is higher proportion of foreign-born workers and unauthorized. This is principally construction, this is agriculture, and various aspects of the service sector of the economy, anything from janitorial services, hotel and restaurant workers, elder care, healthcare, domestic workers, car wash people, to nail salon workers. These are people that we on a daily basis are in contact with. It's not surprising that these also sectors and occupations where workers are underpaid, they're frequently paid off the books and subjected to unsafe conditions. Foreign-born workers are twice as likely as native-born workers to work in these sectors and occupations. The decline of labor standards in these occupations is often a product of broad economic transformation that has destabilized the traditional relationship between employers and employees in this country. Companies that once employed workers under one roof in one single location increasingly outsource their non-core service operations, and classifying workers as independent contractors instead of as employees is also widespread in many of these low-wage occupations. Some studies show that as the range, anywhere in the range from 10 to 40% of employers misclassify at least some of their employees. Now, regulating the labor standards in low-wage sector where outsourcing and misclassification is common is a legal challenge, frankly, because workplace laws typically protect only employees, not independent contractors. Same is true with respect to employers' obligations to pay payroll taxes and contribute to the unemployment insurance, or to procure workman's comp, or to provide health care benefits. They apply only to employees, not to independent contractors. Therefore, it's not surprising that there's a huge incentive for employers to outsource and misclassify employees. The subcontractors that the big employers typically use are small, they're undercapitalized firms who keep costs low and remain competitive by defying all labor standards laws. Immigration law, unfortunately, further complicates the effort to regulate. As Doris pointed out, when we wrote immigration laws in 1986, the core component of that was employer sanctions. It came with the promise that this was lead to unauthorized workers no longer entering the labor market. Now we are more than 30 years out, and it hasn't worked out that way. Under IRCA, it probably surprises many of you that it's not unlawful to hire unauthorized workers. It's unlawful to knowingly hire unauthorized workers. And the knowingly loophole provides a huge incentive for employers to play all kinds of games with that law. Employers shield themselves from sanctions by using intermediary, temporary employment agencies, or simply classify workers as independent contractors. We also know that employers also give an additional weapon in the form of employer sanctions. They choose to verify the immigration status of an employee only when an employee chooses to assert any of their labor rights. And this legal position was further complicated by a 2002 Supreme Court decision, popularly called Hoffman Plastics, that held that an unauthorized worker who was unlawfully terminated is not eligible for back pay. Essentially, that immigration law trumps labor law. Therefore, the effect is that despite the threats of immigration enforcement and sanctions, it has not reduced unauthorized workforce. All it has done is simply pushed many of them into the underground informal economy. The combination of all these factors has led to widespread workplace violations. Studies in New York, California, and Chicago estimate that up to 26% of low-wage workers are paid less than the minimum wage. Another study estimates that labor standards violations could cost all low-wage workers in the country about $50 billion annually. In addition to wages, misclassification deprives employees of workmen's compensation and unemployment insurance. Now, and these things have consequences at various levels. The obvious, these violations hurt both US and foreign-born workers. They make it difficult for law-abiding employers to compete against companies that cut costs through non-compliance with these laws. Estimates suggest that employers who misclassify employees can decrease payroll costs in a range from 30 to 50%. And lastly, they deprive states of very critical tax benefits. So given this, how do you regulate this behavior? The two obvious vehicles are private litigation and federal enforcement. But both of these have structural and resource limitations. First on the litigation. Individual workers don't have private right of action to enforce workman's comp and unemployment laws in our country. Secondly, when they do, there's retaliation. Workers are justifiably afraid of retaliation. In one study, nearly half, I think maybe 45%, of the sample workers who made complaints to employers reported facing some form of retaliation. In the federal context, U.S. Department of Labor is the principal federal agency with jurisdiction in this arena. Even setting aside today is the current regulatory or non-regulatory turn in the federal administration, the U.S. Department of Labor has always faced resource constraints. In the best of times, the Department of Labor had 1,000 employees or inspectors to cover 8 million workplaces in the country. You just have to do the math. Thus, given this reality, we explored what states and localities are doing in this arena. And we learned, to our huge surprise, that the role that states and localities are playing in the workplace enforcement today is underappreciated, understudied, and now become one of the most important critical components of regulating low-wage workplaces in the country. There are three reasons, in my mind, for this activism by the states. First is that states have vested financial interest in this phenomenon. Companies that underpay workers and shift workers off payroll deprive state governments billions in taxes. This has real impact on their budgets. Second, wage and hour violations that lower the income of low-wage workers increases the reliance of these workers on the local social services, which are expensive. Third, states are the primary regulators of workman's comp and misclassification, and any misclassification schemes that avoid paying workers' premiums sort of drive up rates for all honest legitimate businesses. And lastly, probably most importantly, states and localities have a broad array of administrative, licensing, civil, and criminal enforcement powers to deter and punish violators of various labor, insurance, and tax laws that federal government is not able to match because states have uniquely potent tools which is easier for them to employ. The example I like to say that if an employer has not paid his or her workers for months and the U.S. Department of Labor brings a complaint against you, they can at best try to negotiate what part of the areas, what part of the dues that you have you will pay. They won't be able to shut you down. But on the other hand, if a New York State inspector finds one roach in a restaurant, you close it down in a day. That's the level of the difference of the impact between these. And in doing this report, we were impressed by, the roach is not the best examples for this phenomenon. We were impressed by the wide and the innovative variety of the use of state power in using the distinct leverage they have. They're not only using this leverage, they are using it strategically, especially in a world when they have limited resources. How the strategic leverage is being used in the states that we studied for this report is what my colleague Andrew Elmore will describe for us.
Good afternoon. Thank you to Migration Policy Institute for supporting this project, in particular to Doris, as well as Michael Fix for their long-standing support of the project, as well as to my co-author, Muzaffar Chishti, who, in addition to his important contributions to the report, also has played an important role in persevering through this project in order to drive it forward. I'd also like to thank Abby Hudgens and Julie Sue, as well as Amanda Terry, for speaking with us about their agencies, as well as participating today in this event so that they can share their own experiences with strategic enforcement through state enforcement tools. And I do have some ground level experience with this until 2015 as a former section chief in the New York Office of Attorney General, leading and supervising civil investigations of employers for misclassification and labor standards violations, also oftentimes working alongside criminal prosecutors as well as other agencies. And I developed a deep appreciation not only for the unique stake of state and local government in these problems, but also the potent civil and criminal enforcement tools available to these jurisdictions. So that's what I'm going to speak about now. I'm going to discuss the civil enforcement tools and criminal enforcement tools available to these agencies. Then I'll turn to some innovative strategies by state and local jurisdictions to uncover and detect violations as well as to resolve them. And lastly, I'll finish with some of the key recommendations that we provide in our report to these state and local governments. So to begin first with civil enforcement tools. State and local governments have civil enforcement tools at least as strong as those of the federal government, as Moose alluded to earlier with his roach example. To begin on the left, state and local governments oftentimes have powerful inspection and investigation powers, including issuing subpoenas for witnesses and testimony without having to first go to court. Second, adjudication power, the ability to create administrative procedures to adjudicate specific claims of misclassification or labor standards violations. And third, the issuance of administrative orders, again, without having first to go to court, to award restitution as well as to provide for injunctive relief in order to cure illegal conduct by an employer. To provide three examples, one of each of these, beginning with investigations, the New York Attorney General, like many state attorneys general, resolve complaints of labor standards violations through their investigation powers. The New York Attorney General has reported that since 2011, it's recovered more than $30 million for over 20,000 workers in the state, primarily through the use of its civil investigation powers. And one important example of this, an initiative to investigate noncompliance with wage and hour law in the fast food sector, the New York Attorney General responded to mass complaints of minimum wage and overtime violations by issuing dozens of subpoenas to franchisees representing some of the largest fast food brands in the country. This then led to administrative resolutions of those subpoenas and also to civil litigation, totaling over $5 million in restitution, but also a systemic lawsuit against, in this case, Domino's Pizza, as a putative joint employer of these franchise store employees. Turning next to adjudication. The California Labor Commissioner does have investigation powers as well, but in addition, it has the largest system of handling wage claim adjudications in the country. It handles over 30,000 wage claims per year, and in 2015 reported that it had issued over $100 million through its orders through various adjudications. It has also used this power strategically. An important example is in the transportation sector. After receiving complaints of widespread misclassification of port truck drivers, the truck drivers who drive to and from ports in Southern California, the California Labor Commissioner adjudicated 400 separate claims of misclassification, finding not only that the drivers were misclassified, but also owed $46 million in owed wages. This not only protected these individual workers, but of course collectively protects the rights of truck drivers or port truck drivers throughout California to be treated as employees instead of as independent contractors. Third, turning to orders. Importantly, orders can call not only for owed wages, civil monetary penalties and the like, but also forms of injunctive relief. In particular, so-called stop work orders to shut down a business until the business comes into compliance, usually with workers' compensation laws. And here, I'd like to introduce an important state initiative from Florida, Operation Dirty Money. And it's worth pausing a moment to describe this particular scheme and the initiative used to resolve it. In Florida, there is a pervasive practice in the construction industry of contractors seeking to hide their workforce by creating fictitious companies or shell companies and then procuring bare workers' compensation policies for these companies, and then using check cashing institutions to cash checks which they can then use to pay their employees in cash. Now, the problem historically for regulators is that by the time they caught wind of these types of schemes, in construction, projects are usually short-term and end, so the contractor will long have since disappeared. In response, Florida, with Operation Dirty Money, attacked the problem by first starting with the check cashing agencies, reviewing the cash checks for suspicious amounts associated with construction companies, and then searching in the workers' compensation database to see if those companies had bare workers' compensation policies, and if so, sending an inspector directly to measure the workforce on the work site. This then enables Florida to issue a stop work order immediately to shut down the operation until the contractor complies with the law. Florida has used this stop work orders extensively, reporting that in a single year it issued over 2,400 stop work orders in connection with payroll fraud. Turning now to criminal enforcement. State and local governments also obviously have broad criminal enforcement powers. This oftentimes includes underpayments, which, if they are intentional in many states, constitute a form of wage theft, which can be prosecuted either as wage theft or as a form of larceny. And in most states, failure to procure workers' compensation or to contribute to unemployment insurance is a form of payroll fraud, is a felony. Notably, in the states with the most successful use of criminal prosecutions, including Florida and California and New York, criminal enforcement in this context is typically built on top of a robust civil enforcement regime that can identify criminal conduct and then refer it for prosecution. And here, Operation Dirty Money is another important example of the use or strategic use of criminal enforcement. The key limiters or limiting agents in criminal enforcement are A, that there needs to be sufficient evidence to meet the higher burden in a criminal case, but also the availability of dedicated and experienced prosecutors to prosecute the case as a form of white-collar fraud. Florida did both of these first by using the evidence obtained through its civil investigation, then for its criminal referral, in other words, conducting the investigation before the referral is even made. But then second, the Florida legislature has funded dedicated prosecutors in various counties throughout Florida who specialize in handling workers' compensation fraud. This then led to, in 2013, the referral of 475 cases for workers' compensation fraud, the identification of $500 million in fraudulent transactions, and ultimately shut down over 40 fictitious companies. The New York Attorney General and California Labor Commissioner have also used criminal enforcement to support or supplement their civil enforcement initiatives. In the fast food initiative I referred to earlier, one franchisee was found to have, in addition to having violated wage and hour law, had been penalized before for that by the United States Department of Labor. The franchisee not only continued its practice, but hid its practice by keeping a double set of books, so that the New York Attorney General determined that merited a criminal prosecution in that case. So key to all of this, using civil and criminal enforcement tools are the availability of timely and relevant information in order to target employers effectively, and second, the ability to cross agency lines to pool resources as well as coordinate enforcement tools in order to take advantage of the various enforcement tools held by each agency that regulates the workplace. To begin with civic engagement, to build an institutional culture that is welcoming to low-wage workers, and particularly immigrants, the California Labor Commissioner launched an initiative called Strategic Enforcement with Community Partners. It designates special units with trained investigators who work closely with workers' advocacy groups and trains inspectors to prevent retaliation by obtaining complaints from workers prior to conducting an inspection, as well as other means to encourage complainants to step forward, including taking off the requirement of Social Security numbers on complaint forms. Turning now to multi-agency collaboration, states identify targets not only through complaints, of course, but through their own data. States have used a task force model for data mining, as well as to ease the process for referrals and to tailor the enforcement tool to the severity of the violation. Now, Washington State was an early pioneer of data mining for workplace regulation. It realized that instead of conducting random audits, it could increase its frequency of targets or its hit rate by cross-referencing data that would tend to show misclassification. So in a classic example, if you have a transportation company that only lists 5 employees, and yet they own 40 trucks and have previously been investigated for misclassification, that employer is much more likely to be engaging in misclassification than a random employer. In order to do this, workforce agencies, but also the Department of Revenue and various other agencies that hold employer data, and held the data or holds the data in an independent platform, and then cleanse from that data set any data that cannot be used either for privacy or tax law reasons. In doing this, the agency then was able to target its auditing to employers likely to violate the law. It reported that in 2014, it was able to improve its hit rate for audits up to 88%, and was able to recover over $150 million in delinquent workers' compensation premiums. And importantly, it made its enforcement more efficient. It reported that for every dollar it spent on enforcement this way, it was able to collect $9.30 in unpaid premiums. Tennessee is another important example of an agency that has, or agencies that have improved their strategic enforcement through a task force model. Headed by the Tennessee Bureau of Workers' Compensation, the task force has recommended and received from the legislature the ability to issue civil monetary penalties for violations, and importantly, in a budget-strapped jurisdiction, to earmark those penalties for affirmative enforcement. Additionally, it has received authorization and funding to build the kind of fraud detection software that Washington State pioneered. So these findings lead to a number of recommendations detailed in the report, and importantly, many of these recommendations are revenue neutral for state and local agencies. First, maximizing the use of state and local administrative power. Agencies that primarily rely on a first-come, first-served approach to handling complaints can develop a strategic enforcement approach by targeting low-compliance sectors in the economy and by using high-impact civil and criminal enforcement tools to resolve complaints or violations. Legislatures in these jurisdictions should consider providing important civil enforcement tools to these agencies. Importantly, civil monetary penalties, the ability to enjoin businesses that are out of compliance, either through a licensing regime that can be suspended or revoked, or through stop work orders. Additionally, the creation of an administrative vehicle to adjudicate claims is particularly important for low-wage workers, oftentimes in immigrant communities, who otherwise would lack access to justice in order to assert a complaint. Third, the creation of a wage bond or wage insurance requirement to enable the worker to collect on unpaid wages in instances in which the employer is judgment-proof. As in Tennessee, jurisdictions with budget shortfalls should consider earmarking some of these penalties for affirmative enforcement. And lastly, agencies can provide guidance to their staff about when to expand an investigation or an adjudication to similarly situated workers. Turning next to leveraging data to target payroll fraud and wage and hour violations. Like Washington and now with Tennessee, agencies that audit or inspect workplaces should consider an analytics approach to data mine in order to improve their targeting capabilities. Building off of Washington State's example, entering into a data sharing agreement is a revenue neutral way to coalesce or collect data into a single repository. Important to doing this will be to identify particular data sets that will need to be cleansed from the data in order to be in legal compliance with tax and privacy laws. Third, criminal enforcement to prosecute egregious labor, safety, and payroll fraud violations. Importantly, in jurisdictions that have no or weak criminal laws with respect to misclassification or labor standards violations, legislatures should consider appropriate criminal sanctions for this conduct. In addition, those criminal cases that are targeting misclassification should also consider wage theft, since these problems are oftentimes intertwined. And lastly, in order to encourage complainants to step forward, particularly in a criminal case, there's a need to think about ways to encourage complainants to step forward. This could include a restitution fund for labor standards violation victims, as well as the establishment of a protocol for certification of a U visa, which, as many of you know, provides certain immigration law protections to cooperating witnesses. Fourth, strengthening private stakeholder engagement in public enforcement. Engaging with private stakeholders is key for these agencies because it deepens their knowledge about illegal workplace practices, it encourages complainants to come over, and with respect to employers, it can educate the employer community about compliance with the law. Agencies engaging with private employers and immigrant communities will need appropriate interpretation and translation services. And to encourage complaints, as with California, agencies should aggressively treat allegations of retaliation and consider a model of criminal referral in egregious instances. And also to remove information that's now required on forms that may discourage workers from coming forward. Lastly, building cooperation between state agencies and between state, local, and federal governments. State and local agencies rely on and in fact benefit from collaboration, both across to different state agencies and different local agencies, but also vertically with the federal government. For example, collaboration with the Internal Revenue Service on sharing of targeting data for workers' compensation fraud has been critical and used for a long time. As with Tennessee, multi-agency collaboration can begin by identifying the sectors in which misclassification in this instance is most likely to occur. in the Tennessee example, in the construction sector was the original focus, and where concentrating enforcement can have the largest deterrent effect. The task force can encourage cross-agency pooling of data to improve targeting, as well as coordinating referrals, both for multi-agency investigations as well as criminal referrals. Thank you.
Okay. We're going to turn now to our guests by video, California and Tennessee. Let me first express my appreciation to both officials for participating to the very full and interesting explanation here that we held a roundtable with a draft of this report a while ago, where we got labor unions from other immigrant advocates that work in this realm, as well as from states. Involved in the research, but these two states, California and Tennessee, have been particularly helpful and particularly exemplary engagement with these issues. Now, they're quite different states. California has a very different history of involvement with issues like this. Tennessee has been more newly involved, certainly in terms of their immigration histories. Tennessee is what we would think of as a new. California, of course, has been a long-standing immigration destination. But these are both people and agencies that have been very innovative and very committed to this work. So we're particularly pleased that they've been involved and are here with us today. So let me turn first to California and to Julie Sue.
Thank you so much, Doris, and thank you to Andrew and Moose for the report. I'm really honored to be here with you all today, just to connect some of the themes that have already been stated. One of the things that is important to note is that California has had explicit legislation for over 15 years, and that legislation actually declared that the law has always been this, which indicates that immigration status is irrelevant to the question of whether you're entitled to labor law protections. So that is something that has been stated clearly in our labor code through Republican and Democratic administrations. It's not really considered a partisan issue so much as it is a very practical approach to making sure that vulnerable workers feel protected and are entitled to basic standards in the workplace, regardless of their status. Of course, current activities at the federal level are challenging, if not in direct, legal ways against the statute, then certainly in their practice, the reality of that protection, given that the work site has been used as the place for enforcement of immigration laws. And we have seen the reaction, which is workers feeling more afraid than ever to come forward and report wage theft and other abuses, which is obviously a challenge from an enforcement perspective, in addition to it being damaging on a number of other levels. The other thing I just wanted to mention, and I really appreciate the recommendations of the report, and I just wanted to say that, overall, the approach that I have taken to my role as the labor commissioner is to be very clear that our job as a government labor law enforcement agency is not to be neutral. We're not a neutral agency. We're on the side of the law. It's our job to enforce the labor laws. The labor laws are not neutral about what standards should exist. And so sometimes when we do enforcement and an employer has broken the law, has stolen wages, has made it a business practice to underpay or work workers off the clock, or to pay in checks and then cash it on hand and take some of the cash back. All of those kinds of practices are illegal, and we are not neutral about what we're going to do about it. So when those employers complain that, it seems like you're biased against us, it seems like you're not on our side, our response as the Labor Commissioner's Office is to say, we're not supposed to be on your side if you've broken the law. And I think that approach has informed many of the changes that we have made to become more effective as an enforcement agency. And I think that is a theme through the recommendations that are made in the report as well. And especially given the incidence of wage theft that is documented in that report and in others, it's critical that we play a strong enforcement role and are clear about our mission. I often analogize it to if the only penalty if you robbed a bank was that you had to return the money, then many people would consider bank robbery a risk worth taking, right? If the worst case scenario is that just you return what you took, then you're really no worse off for having tried. And that's obviously not the penalty only for robbing a bank, and it shouldn't be the penalty for wage theft either, to just return what workers should have been paid. We don't want people to have a, why not try attitude about bank robberies, and we certainly don't want them to have a why not try attitude about wage theft. So I just wanted to highlight a couple of things and go into a little more depth on some of the examples that Andrew gave. As he mentioned, in California, we do have a wage claims adjudication system. We hear over 30,000 claims a year in one of 16 offices across the state of California. And this is a powerful way that individual workers can step forward, file a claim, get their claim decided. We often help to resolve claims even without a hearing. Sometimes the employers just really didn't think the worker would ever speak up. So once the worker does come forward and we get involved, they're willing to resolve the claims. Now, one approach we've taken along the lines of, we're not really just trying to put money into workers' hands they should have had all along. We really want to try to deter future violations is we take the approach that, our job is not just to arrive somewhere in the middle. We're not just trying to settle claims. If the worker claims that they're owed $10,000 and the employer says they're owed none, we don't consider $5,000 a good result if the worker actually was unpaid. At a minimum, we want to make sure the workers get what they should have been paid. And on top of that, there are many statutory penalties in California that incentivize employers to comply in the first instance. Also, to the point of misclassification, which was mentioned earlier, one of the pushbacks we've gotten in cases about misclassification and in the port trucking industry, which Andrew mentioned, this has been very, very pronounced, is that the industries will say, well, these issues are really too complicated for the Labor Commissioner's Office. These cases really should be resolved in court. They're really not appropriate for the administrative system. And our response to that is oftentimes the more complicated the issue, the more the exploitation, right? That issues are made complicated in order to obscure violations, to confuse workers, to make them not understand exactly who employed them and what rights they had. And so oftentimes, if they are complex, that's a sign that we should not be running away from them, but we should be running toward those cases and actually do something to try to rectify the violations. So as a result, we have adjudicated over 400 claims in the port trucking industry alone, finding over $45 million owed since 2012 to drivers in that industry. And we've had a number of other misclassification cases that we take on because we recognize that it's important for the state enforcement agency to make sure that misclassification does not occur, because that's critical to ensuring that the basic labor law protections that rely on employer-employee status are actually meaningful and real. The other part I just want to mention about wage claims is, especially in light of the increased vulnerability of workers and the fear of coming forward, is we launched a Wage Theft is a Crime campaign in 2014. And the tagline, Wage Theft is a Crime, is not an accident. We thought long and hard about using the term wage theft, which I'm really happy to see is much more common lexicon now to talk about what it really is, which is, workers getting something that they earned stolen from them, but also indicating it's a crime to show just how significant, how important such violations are, and how damaging. And so that campaign, we use billboards, we use advertisements on bus shelters and bus sides along paths where workers traditionally use for transportation, and we use radio spots on English language, but also Spanish, a number of Asian language radio stations, to just get out the word that what wage theft looks like, the many forms that it takes, and the fact that workers could make a complaint to the Labor Commissioner's office. I want to shift now to talking about our strategic enforcement approach, which Andrew also mentioned. We launched an effort to make sure that we were not using random inspections, right? This practice, which was prevalent in the past in this office and is sometimes utilized by government agencies because there's a sense that, it's hard to, are we allowed to pick and choose our cases? Should we just have to take whatever complaints come in and investigate them on a first-come, first-served basis? I have found that is not an effective way either to enforce the law or to use limited resources. So our strategic enforcement approach is to target certain industries in which wage theft has been studied and is considered very common. There are also industries in which California law has recognized that there tend to be high violations. And so in those industries, we have specialized teams who do in-depth investigations of employers and up the chain employers who break the law. And those industries are car wash, janitorial, restaurant, residential care, agriculture, construction, and garment. And it's not to say that those are the only industries in which wage theft occurs. We do inspections in other areas. We do have wage claims that come in every possible industry. But in those industries, we have found that it's really important to find the bad actors who are not only breaking the law themselves, but are really shaping behavior in the industry, that their behavior actually incentivizes other employers to break the law. They say, we can't comply because these other players don't comply either, and it's creating a race to the bottom. We want to end that race to the bottom. And so we have partnered with community-based organizations in each of those industries who help us to identify the bad actors and then to help us talk to workers, right? They are organizations that work inside of communities. They have legitimacy and credibility. They have the trust of working people, and they're willing to work with us so that we can actually use our resources and go to the place where workers are motivated to speak up, talk to them in a place where they're safe, right? Instead of just going to the workplace to do investigations, where interviews are done under the nose of the employer, we can do off-site interviews to try to figure out what's going on in the workplace. Are there false time cards? What are the actual hours of work? And to actually go into the inspection once we're armed with this kind of information first. So we're really grateful to our partners who have engaged in this effort with us. And one of the changes that has resulted from that is that in the 10 years before Governor Brown was elected here in California, the hit rate, basically the rate of citations to inspections, hovered around the 40% range, which means that less than half of inspections actually resulted in a finding of some violation. And you can all imagine, right, that is not good for workers who feel like inspections are done, but there's no result from that. It's not good for employers who feel like, well, if I'm compliant, why am I wasting my time? Why is the Labor Commissioner coming in to investigate? It's not good for government, and it's really not a good use of resources overall. And so we have dramatically turned the tide on that. With our strategic enforcement in particular, our hit rate, unsurprisingly, is really at 100%. We are going to places where there are violations. And our general change in our approach, our elimination of random sweeps and using more data-driven inspections has led to a hit rate in the non-strategic area of over 80%. So those are positive results for everybody involved. Just a couple of cases we recently had. We issued a citation against a restaurant on behalf of 24 workers for over $500,000. There were common elements of wage theft. Workers were working off the clock, right? They clocked in after they started. They kept working after they clocked out. They were paid on a per shift rate, which when you calculated hourly did not come up to the minimum wage. And so those are classic wage theft violations. We were able to find them through the help of our partner, and we were able to issue citations. We also issued a $7 million citation against residential care homes on behalf of 149 workers who were live-in caregivers. Also, wages stolen on a regular basis to the tune of $7 million. And that's not just the wages owed, but also penalties and other payments in order to, again, make it more costly to break the law so that employers don't have a why not try, it's worth taking a risk approach. And so our strategic enforcement has really had some very positive results in that way of uncovering wage theft, of gaining the trust of workers, of being able to work with workers through the whole duration of an investigation, and then of being able to have workers willing and able and with the backup to come forward and testify when our citations are challenged. One last thing I'll say is that we also enforce anti-retaliation protections in California, and we've seen a real rise in retaliation. And specifically, we've seen a rise in immigration-based retaliation, which is, again, no surprise in light of the comments that have been made here today. In all of 2016, we had 19 complaints of immigration-based retaliation. That means that the employer says to a worker who comes to file a wage claim, or a worker who complains about wage theft, they say, I'm going to call ICE on you. I'm going to have you deported. You shouldn't be in the country anyway, and so now you're fired. In 2017, in that year, we had 90 claims. So it grew by over 4 times. And so we're seeing that employers are really emboldened in this climate to use immigration status as a weapon against workers. And that's certainly something that we're cracking down on. We have 4 cases pending in courts against employers for doing this. And we are doing everything we can to demonstrate that we are going to hold employers accountable for abusing workers and trying to chill workers from coming forward based on their immigration status.
Julie, thank you so very much. I want to apologize to the audience that we don't have a bigger image of Julie, but you could see her to a degree, and you could certainly hear from what she was talking about why California is such a leader here and why Julie herself, as the labor commissioner, is a real voice in this field. So thank you again for participating in this work with us, as well as here today, and thanks in advance for staying with us for the Q&A. Let me turn to another very important leader and very interesting state in this terrain, and that is Tennessee, and Abby Hudgens.
Good afternoon. Thank you for having us. Our story is a bit different from California. We are focused on misclassification as it relates to workers' comp. And our story, I think, is interesting and is one other states might be interested in knowing how we got to this point. About 10 years ago, we had a grassroots effort of people who were concerned about this issue. And we really had no stakeholders who were against the concept. It started with our advisory council on workers' comp, and the whole issue was around those employers who were not fair to other employers by avoiding paying unemployment, avoiding paying workers' comp premium, and then, of course, walking off when one of their employees got hurt. So a task force was formed about 10 years ago as a result of this grassroots effort. And it had representatives of Commerce and Insurance, the Department of Labor, the District Attorney's Office, the Attorney General's Office, the TBI, which is our Tennessee Bureau of Investigation, the Bureau, the NFIB, the Chamber, Construction Licensing Commission, and several construction groups. So it was a very broad-range group. They had a specific task, which was to bring to the legislature ways to make a difference in the construction industry where there was misclassification. Now, one thing that helped our initiative, it was done so that there really wasn't a group that would say, I'm being disadvantaged, because we had good employers who were doing the right thing, and they were having to compete against employers who were acting illegally. So, and those, of course, could not come to the legislature and complain. So the task force met for about 4 years. They came forward with legislation that provided a way to pay for the program, which is through an exemption registry program. That program allowed an employer to exempt himself. Modest fee, but it provided enough money to get this program started. Once the program got started, we had legislation that authorized the hiring of inspectors. It authorized money for fraud detection software. It authorized us to have a separate fund that was not touched by any other funds. It was not subject to being rated. So all the assessments that we collected and all that exemption money that was collected excuse me, went into the Employee Misclassification Fund. So we had a situation where there was not a stakeholder group that was lobbying against the initiative. We did not have unhappy employers who were having to pay for the initiative. It was self-supporting. So we really were able to have a broad base of support. Now, the task force sunsetted in 2014 because their task had been done. But I think it's interesting to note that there was such broad support that all the members of the task force stayed on as voluntary members of our Employee Misclassification Advisory Council. So we have worked very closely with them. One group I didn't mention was the insurance industry. They've worked with us, and they are continuing to work with us. We are now trying to find ways to work with insurance auditors. Again, it's a way we have collaborated with another group to find ways to reduce the amount of misclassification. The monies that we raise not only pay for the program, but they help pay for benefits for those employees who may have a work comp injury and there's no employer who's willing to provide the benefits. So we think that this collaboration model has been very successful for us. There's been a lot of interest expressed by other jurisdictions to hear about what we've done. I think that I'm also hearing many other state jurisdictions who are interested in doing the type of thing that we're doing in Tennessee. Basically, if it was undercover 10 years ago, it's got a face now, and there is much more support and just downright horror at some of the things that happen. Now, ours does not necessarily have any program. Our program does not have a connection to migration as such, but of course, in the construction industry, so many of the people who are misclassified are people who don't have legal status in the United States. And that does make it more difficult for them to speak up for themselves. And because so many of those are from countries where they speak Spanish, that has been an issue for us as well. So in the last year, we've launched an initiative to the Latino community and have used some of our staff who can speak Spanish. We've gone out to Spanish or to Latino businessmen, and we are spending a lot of time trying to eliminate the fear of our agency. Since we're a government agency, there is that natural concern about, are you going to turn us in? We are not immigration. We are strictly about misclassification. So we don't deal with that at all, and we never have had any interaction with ICE. The groups we do have interaction with would be the Bureau of Investigation, and they would be the district attorneys. But those are where we think there's a criminal case involving misclassification. We have had some cases that rise to the level of slavery. We think, and those we have turned over, and there have been some criminal prosecutions. We have been relatively successful with assessments. Over the last 4 years, we've probably assessed over $20 million. But one thing that we think is important is the broad base of support, and that support continues every year as we look for ways to make the program more effective. We did use software for a period of time for fraud detection. And what we've discovered is that we are going now in the process of beginning to develop our own in-house program. We have access to a number of sources of data. Again, our problem is directed solely toward workers' comp, so our data sources are a bit different. And we use those to try to find ways to identify possible cases of misclassification. We, as California, we do not rely just on tips, although we're happy to get those. One of the other groups we try to collaborate with are union groups, because they are on work sites and they often see where there's a problem. It's been our experience that the primary contractor is not where the problem is in construction projects. It is usually the third or fourth subcontractor. We call these people labor brokers. They're not really contractors. They are people that take advantage of other people and bring them on the job and call them independent contractors. So we have an active program to deal with that, and that has been our focus for the last 4 years. We also work some with the Federal Department of Labor. We have a memorandum of understanding with them. Their focus is a little bit different. It's on wages, but we do find areas where we can work together. I think it's just important for the word to get out, and it's not only about people who have immigrated, but it's about all employees who may be treated unfairly. And it's also about employers who do the right thing. As the commissioner from California mentioned, it's difficult for people to continue to do the right thing if they see someone who is able to cut cost and profit from that, and they're continuing to do the right thing. So we have a lot of incentive in Tennessee to bring an end to this process. Although I have discovered that sometimes we are like the little boy in the dike. We plug up one hole and they try to figure out another way to continue their practices. So it's not an issue that we by any means think we have solved. Amanda, did you have anything you wanted to add?
Just to the point that you were talking about with labor brokers and that sort of thing, we had a recent case with a labor broker and our bureau determined that they were subject to a penalty, and it was a hefty penalty which the employer paid in full, and we were told by the employer that he was going to shut down his business, and he did for a small time and then reopened under another name, like the shell company that the commissioner in California was talking about as well. And so we do find that to be problematic for our state too. So
Sort of the bottom line, we feel like the state has a big part to play in solving this problem, and that has certainly happened in Tennessee.
Tennessee. Thank you very much, Abby. I mean, it's quite a different, you can just tell by listening to these two people the different circumstances in which they're working and the different ways in which they've approached their constituencies, their histories, their particular issues, and they're just, I think, really fascinating case studies. The Tennessee in particular, the way in which you put together what you call your collaborative model, I mean, really getting buy-in from all of the different parts of the spectrum that would be affected, and recognizing that, among others who are hurt by these bad practices, employers themselves, fair employers, who of course are the majority of employers, are very much harmed. But so you can't just look at employers per se as the enemy. Most employers, in fact, want to be on the side of these kinds of proper compliance with the law. So, okay, we've given you as good a cross-section as we can of this work and of the sort of unusual nature of the things, interesting things that are developing and that have been developing in recent years. So the floor is now open for questions. Let me say to our live stream audience, I will repeat that you can tweet questions to @migrationpolicy. You can use the hashtag MPI discuss, or you can email events@migrationpolicy.org. We are, as I said, because we're being live streamed, those of you who are in the audience, I would ask that you wait until the mic comes to you once I recognize you, and then tell us who you are and your affiliation. So I'm looking for hands in the room, right here in the front.
Thank you. My name is Jasmine Moa Barrientos. My affiliation, I'm a Senate candidate for Virginia. And my question is about discrimination. It is not an issue anymore, just the retaliation of an employer for someone that is not documented. But now in Virginia, we see some employers that are also asking for natural born employees. I even have a recording of someone saying, I don't want to hire you because I'm looking of someone with white eyes and I'm sorry, with white skin and blue eyes. How about white eyes? I'm so sorry. That's kind of impossible. But however, yeah, exactly. It's like, however, when we talk about discrimination, it's very easy to tag someone individually. But I've been facing an issue when it talks about independent contractors, because the law pretty much doesn't help the independent contractors, and the only way that they can go for a lawsuit will be based on their contract. And some of them doesn't have a contract as an independent contractor, and seems very hard for me to be able to tackle. And I want to know your opinion as a government, how these people can be helped.
I think she'll come around and give it and get it from. I think if either Abby or Julie could answer that. Abby, you've talked a lot about contractors. Could you help with that?
This is Abby Hudgens. I can speak to that a little bit. We don't, it is not evidence to us for an employer to call an employee an independent contractor. It is in our law, and there's 7 factors. In federal law, I think there are 20. But you could call someone an independent contractor, and yet if there were those elements of control, if those 7 factors were met, and they all are around control, we consider that an employee. And it really doesn't matter what the employer might say. That's the way we approach it in Tennessee.
All right, that's helpful.
That's
Julie,
true
Julie,
also in
anything to add to
California.
that?
So I agree with my colleague in Tennessee. What Abby said is true here. There's a presumption of employee status, in fact. And so it's up to the putative employer or the entity that's claiming independent contractor status to justify that status. And I would say to the question, that's a threshold question before you even get to the questions of discrimination, right? I mean, this is the whole point of misclassification, is to try to take working people out of the protections of employer-employee laws, and tackling the misclassification first is really critical to that. And I know in California, at least, our investigations of that kind of discrimination, whether it's national origin discrimination, race discrimination, is in a different state agency. It's the Department of Fair Employment and Housing. But we do have an agency that does investigate those complaints too, and will bring suits in court against employers who engage in that kind of discrimination. They will do the misclassification analysis before they proceed as well, though.
Just on your first part of the question about people insisting that you must be naturalized, you must be native-born American first. I mean, that's clearly a violation of federal law. When employer sanctions were made part of a law, we also created a separate branch in the Department of Justice called the Office of Special Counsel, whose only jurisdiction is to go after discrimination based on national origin or alienage. And they're very effective tools, so I would suggest that that's the easiest part of that to enforce, and that has a lot of leverage.
In the back.
Hi, I'm Nady Dominguez. I'm an organizer with the International Union of Painters and Allied Trades. And my question, in our industry, misclassification, it's a big issue in the construction industry. And one of the biggest challenges we face is workers themselves knowing that they have been misclassified, but because they're undocumented, not being willing to come forward because that is actually the most protected legal form that they can use their individual taxpayer ID numbers to be able to lawfully work, right? Because they don't have social security numbers that then we can push the employers to actually have them on payroll and have them, you know, be full workers. Now, we know and we agree with both the California um, representative and the Tennessee representative that, you know, the law is on our side, but it is really hard to enforce it when the workers are fearful. And in fact, because of federal constrictions, this is like actually the only way many workers can lawfully work without having to lie or to their employers or you know, any other agency. So I was wondering if there were thoughts and or some of the tactics that some of the government agencies have dealt with this issue, specifically how to support the workers through this process when they're fearful of retaliation, but overall when they're fearful of just not being able to have a job.
Julie,
Absolutely. So I think that's an excellent question. It's certainly something that I feel like I grapple with every day on the job. I think that certainly, right, it's one thing to say what the law is. It's a very different one to say what the experience in real life of workers is. And I think for us as a state agency, and I know Abby mentioned this too in Tennessee, one, it's really important not just to be silent about this issue, but to be proactive about saying who we represent, who we serve, and who our doors are welcome to. I just think that we have to provide a counter voice to the other voices about what, you know, government is doing and could do to immigrant workers. So that's one step. But I will say that for us, the strategic enforcement model of working with groups, and I do have to credit the questioner, Nady, was actually in California for many years and helped to establish one of our key partners in the car wash industry right now. But working with an organization like that continually engages in on-the-ground work, in organizing, right, in empowerment work with workers makes a really big difference. So that they are coming forward to speak to us. We're making steps to make sure they do it in a place where they're safe, right? If we're trying to minimize the risk of retaliation, then going on site, conducting an inspection, asking workers in front of the employer what's going on in the workplace is almost an invitation to retaliation, right? It's very clear to the employer who's talking and who's not. And it's a very easy way for employers to coach and otherwise threaten workers from talking to us. But doing the off-site work, doing the advanced work before we do inspections so that workers are in a safe place with an organization they trust has helped us tremendously to push back on that very real risk that you mentioned, Nady. And then the last thing I'll say about this is what was already mentioned in the report and what Andrew mentioned, which is there are some tools. I mean, there are restrictions to them, so I don't want to overstate their value. But where if a worker is a victim of a crime, and that crime could be obstruction of justice, right? And a lot of times the threats to workers who come forward constitute an obstruction of justice, then or witness tampering, right? Those kinds of crimes could qualify an individual for U visas, and we do certify U visas. And we have some sense, even in this current federal administration, that U visas will continue to be granted, and that those workers who apply are not going to be reported to ICE. Now, you know, assurances at this point about that are obviously anybody's guess. So we're cautious, but that is one federal tool that has been available and has not been repealed.
okay,
In Tennessee, we have the same issues that we face on a daily basis. I know it's one of the most difficult aspects of our investigators and our team that try to investigate these cases. That's one thing that we do is we train our investigators to talk with these people. But the main problem we have is getting the people to respond and to actually talk to us. Most of the time, what we see in our cases is they just completely shut down and shut us out and don't return calls. That's why I think, and I feel certain Abby feels the same way about the Latino and Hispanic outreach. That has been very important for Tennessee this year.
to start those kind of conversations, to go in to the communities and to introduce ourselves and to have the open and honest discussions with them and to try to answer any questions. And it would be the same with any community that would, want to have us come in and educate. Today we had another group ask us for some educational help, and we hope that will get that group off the ground as well in that community. But it has appeared that there has been a lot of misinformation or miscommunication amongst the Latino and Hispanic communities, and our outreaches have definitely helped in that regard. We still have things that we need to do and things that we can do, and we look forward to working towards that in the future, but the outreaches have been very helpful for us.
Thank you. Thank you very much. I have a related question, so from the live stream audience. So let me pose it here and give you a chance to add. This is to you, Julie, in California, and it comes from somebody that's listening in San Francisco. The question is, what strategies are you using to crack down on employers who are engaging in immigration-based retaliation? And what do you recommend to workers, government agencies, and CBOs to address the rise in this behavior? Now, we've been talking about that in both of these prior responses, but Julie, if you have anything that you can add about whether what you've seen is acting in any way as a deterrence, or anything that you can add on that issue of employer retaliation, because it's obviously a very important one in this realm.
Absolutely. So the California legislature has passed a number of bills in the last few years. Since Governor Brown came into office, he signed them onto law that provide enhanced protections for immigrant workers from immigration-based retaliation. These include when the employer makes a threat to call ICE, when the employer makes a threat of deportation, when an employer uses I-9 rechecks in a way that's not compliant with federal law, when the employer abuses the use of E-Verify. There's a number of practices that are now in state law as being an example of immigration-based retaliation. And those cases, there's a presumption that retaliation occurred. And we actually also, as an enforcement practice, we prioritize those cases for the obvious reason that oftentimes those workers are extremely vulnerable now, not just for the workplace abuse that they suffered, but if the employer chooses to make good on their promise, it really creates a climate of absolute fear for that particular worker and a chilling effect on other workers. So what my office has the power to do based on these laws is we take complaints and we investigate, and then we actually do expedited investigations. So we try to investigate these cases within 30 days, and then we can go to court and sue the employer to both stop the practice and restore the worker, whether it's putting them back at work or getting them back pay or that kind of thing. The other law that just passed and went into effect just a couple months ago in January is that we can also proceed on those cases now without a complaint. And the reason we wanted that law is that you can imagine for some of those workers who are so threatened, oftentimes they're going to be too scared to then file even a retaliation complaint, right? Once they're told, ICE, I'm going to call ICE on you, I'm going to have you deported, those workers are not going to file a complaint. And the emboldening I mentioned earlier of employers feeling more and more at liberty to make immigration-based threats has resulted in employers making those threats even to my deputies. Threats in my office, right? An employee is there for a wage claim, and the employer will make a threat right in front of one of my investigators. Or they'll call my office and say, you're investigating me? Well, these workers are illegal, and if they're illegal, I'm going to call ICE. And so those threats are made. We're witnesses to those threats. And in those situations where the employee is not going to file a complaint because they're really, really legitimately even more frightened, then we can proceed to investigate without them. So those are some legislative developments that I think try to address the issue. The other, that my colleagues in Tennessee and I have mentioned about the need for outreach. And, a lot of times I feel like our own successful investigations, right, successful crackdown and misclassification in Tennessee's situation, our successful collecting of wages that were owed is its own type of security, its own type of advertisement. If you come forward, you will get good results. we need to do that too. But specifically on that issue, we have had some developments in California that recognize it's a growing issue. In fact, those laws were passed before 2017 and increased ICE activity, and we are now prioritizing those cases and trying to send a strong message that that kind of retaliation is not going to be tolerated.
In Tennessee, since we are the Bureau of Workers' Compensation and we don't have any authority over discrimination, that doesn't really fall under what we can do. However, as I said before, the basis of our investigations are not so much by a complaint. We may get a complaint, but there is a wall of secrecy between the complainer and our investigation. So there's no identification with of any employee when we go to an employer to investigate their patterns on misclassification as far as workers' comp is involved. I do know that the Department of Labor, the Federal Department of Labor here in Tennessee, does look at those types of issues, but that's not part of what we can do.
Okay, good.
From Julie and Abby about the importance of anonymity in complaints. And this extends also to state attorneys general, who oftentimes can commence an investigation based on anonymous complaints and will never ever have to release the names of the particular complainants because they're able to resolve those investigations administratively. This is another advantage of being able to conduct enforcement within an administrative agency, of course, instead of through the court system. And that extends both to attorneys general as well as the various departments represented here.
Any further questions? Okay, then I'm going to ask a final question. So we've had this, broad tour d'horizon now of what's going on in a number of states around the country, but at the end of the day, this is states. And so it is representative of what's happening in those states, but what about the country at large? From your work, Abby and Julie, with other states, what do you see to be the state of play with enforcement of the kind that you're doing in other parts of the country? Is there a potential for more of this? Are other states interested? From our co-authors, in looking at this overall as a research topic and surveying the country, how many states are doing work along these lines and are not? Let me go to Julie and Abby first. Julie?
So, Doris, to take both questions, right? So I'll say on the anonymity issue, that definitely is, it's a challenge. Certainly in our wage claims process, claims are not anonymous, right? The employer is given the ability to face the employee. Now, like I said earlier, oftentimes what we find is that these employers in this informal economy simply break the law because they don't expect to ever get caught. They break the law because they don't expect their workers to ever speak up. So when they do speak up, sometimes we're able to resolve that claim through a phone call from the labor commissioner, for example. And so that's not actually exactly an anonymous complaint, but they do get the protection of the state being on their side, the labor commissioner intervening to try to resolve their issue. On our field enforcement side, we try to protect the identity of individual workers as much as possible. As part of what I said about doing interviews off-site. Our citations are the labor commissioner citations, right? Like, as you mentioned, they're not in the name of individual workers. But at some point, when individual workers are going to be paid, when we do an audit, we do need to name the individual workers who are entitled to wages. So there's some protection in the sense that it's not the worker bringing forth the violation, right? They're not citing the employer, but we do name the individual workers at some point in order to get them paid. In the retaliation context, though, we do have the ability to protect a complainant for a duration of time and to also protect witnesses in retaliation cases. I will say on the state enforcement side, to Doris's question, I feel like there's a lot of really positive developments there. From Washington, D.C. to Washington State, and all in between. I think that the state agencies are really seeing us even more than ever as the front line enforcement, the first and last line of defense for working people, for honest employers, for the basic labor standards that each state has determined is really, really critical to the well-being of our people. And so we do have a lot of openness and exchange of strategies, of information, of everything from legislation to misclassification task forces to campaigns against wage theft. And I'll just give one plug for the Interstate Labor Standards Agencies, or ILSA, is the agency where all the state agencies interact. And this year in August, the gathering will be out here in California. So we hope that folks will join us, and we're really organizing it as a chance to share information and to strategize about what to do to protect the wage floor and to promote economic justice in these tough times.
So Abby, you mentioned in your remarks that you we're kind of a lone wolf with this a while ago, but have had more state interest. Can you talk particularly about the South in this?
Yes, I can. First of all, I would say that as mentioned about Florida, Florida is probably the granddaddy of all states as far as being effective. They have some tools that we might be a little envious of, which is the stop work order, but they are one that has been incredibly successful. But as far as the whole South, there's an association of work comp administrators, which is called SACA, the Southern Association of Work Comp Administrators, although Colorado and Maine are members also, which might rise an issue about what we mean by Southern, but we decided everybody is some south of someplace. But it is very much an issue. In particular, Virginia in the last year and a half has started a program, and it has gotten up and going and is flourishing. I believe Maine is beginning to look at a program. I believe Georgia is looking at a program. And these are people who are actually implementing things. I'm involved in that, and IIBC, which is an international workers' comp organization. And while it's been on the agenda for several years, now there is more intense interest in states doing something about it. They are wanting to see what's worked in other places, but more importantly, they feel they have an urgency about doing something about it. So I'm very encouraged about not only the South, but states outside the South.
Fascinating. Well, I'm going to give our co-authors a final word here, since you're the ones that really surveyed all of this. Andrew, and then Moose.
Well, so this event and hearing Julie and Abby share their experiences see how broad and deep different state and local interests are in this issue, as well as the varied enforcement tools. Lots of different approaches, which suggests that for all these different types of problems, the short-term nature of construction, misclassification, transportation, and so on, there are a variety of different strategies that these state and local jurisdictions that are considering strategic enforcement can now adopt. I'm very glad to hear about its expansion to other states, and hopefully we'll continue to research this issue as it unfolds.
Yeah, if you would consider non-traditional states in this, and have really taken the lead and been really successful and being the models to other states, so that's kind of made them the envy in this world. And I think that is really encouraging. They have also, I think, proven that how you can do this in a really cost-effective way. That if you, in the Florida example you all heard about, it's a fascinating tale to look at this. And all they did was, look, when there's a prosecutor, you have murders to do, you have homicides to do, you have robberies to do. The white-collar crime is very low in your priority. And all you have to do was dedicate 3 prosecutors just to do that kind of crime. That made all the difference. And I think that's the kind of models that people are looking at for enforcement. But let me also just finally conclude that states obviously are playing a critical role here. But at the end of the day, a lot of it has to do with the status of people in the country. And the number of people who are unauthorized, it's 11.2 to whatever 11.5 million you want to use. And they are constantly vulnerable. And the solution to that problem does not lie in the states. The solution to that problem lies in the federal government, especially in our Congress, and it's a paralysis we have watched for a long time, and a dilemma that has to be addressed in Washington, D.C.
Well, thank you very, very much all, particularly Julie and Abby and Amanda. Obviously, our co-authors, Andrew and Moose, and to the audience, both in the room and live stream, thanks so much for your participation.